which have been originally registered in the FIR, and thus is entitled to a notice under section 35(3) of the BNSS, my lord, which is equal to 41A of the old Act, I mean the CRPC. And then interim protection, which now they are not claiming, my lord. So in my written arguments, my lord, I have just mentioned, which I'll pass it on as a brief note I have made.
He has argued the criminal.
No, we are. That's what, my lord. We have. My learned friend said that he wants to argue the anticipated bail application. So therefore, even I agreed that we will conclude it today itself. There is no point. There is no point now further postponing it. I don't want to go into the technicalities of that, my lord, and waste the precious of this honorable court. My lord, as far as the point 1 is concerned, my lord, the Honorable Supreme Court, my lord, in a catena of judgments, time and again reiterated that to determine the age of a person, my lord, as per section 40. Section 34, my lord,
Of POCSO.
of the POCSO, my lord.
Section
34. It says, my lord, procedure in case of commission of offence by child and determination of age by a special court. How do you determine the age? May I read, my lord?
Yes.
Where any offence under this act is committed by child, such child shall be dealt with under the provisions of the Juvenile Justice Care and Protection of Children Act 2015, my lord. So we have to fall back on Juvenile Justice and Care and Protection Act, my lord, which used to be the Juvenile Act, my lord.
No, but this is in case the offence is committed by a child.
No, even it is applicable to what happens, my lord. I'll tell you. Suppose if the case, if a crime is committed by a child, then what they do is, my lord, for that purpose they take the determination. Even for the determination to know whether how do you know, you have to, Supreme Court said that you have to fall back on to the 4 parameters what is laid down as per the Juvenile Justice Act, my lord. There are 3 judgments, my lord. There are several judgments, but I will just point out those judgments, my lord. If any question arises in a proceedings before the special court whether a person is a child or not, such question shall be determined by special court after satisfaction about the age of this person, and it shall record in writing its reasons for such determination. No order made by the special court shall be deemed to be invalid merely by any subsequent proof of the age of the person as determined by it under subsection 2 was not of the correct age of the person. So, my lord, your lordship may kindly go to the Juvenile Justice Care and Protection Act, what it says, my lord. Now, your lordship may kindly go to section 94 of the Juvenile Justice Care and Protection of Children Act 2015, my lord. How do they determine what is admissible? What are the documents which have to be taken into consideration prima facie, my lord, with regard to the age of the child?
Section 94.
94, my lord.
Yes.
Presumption and determination of age. Your lordship may skip, my lord, 1.
Yes.
Then your lordship may go to 2. In case the committee or the board has reasonable grounds for doubt regarding whether the person brought before it is a child or not, the committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence of obtaining 1. Date of birth certificate from the school, that is the first document, my lord, which is a primary document, or a matriculation or equivalent certificate from the concerned examination board, if available and in the absence thereof. Suppose in case if it is not there, then you have to fall back in the second one, that is the birth certificate given by the corporation or the municipal authority or a panchayat. In case the first one is available, then the second and the third are irrelevant. That is what Supreme Court said. And the third is, and only in the absence of 1 and 2, in case if they are not there, above age shall be determined by an ossification test or any other latest medical age determination test conducted in the orders of the committee of the board. One is, my lord, ossification test, another is a radiological test, and another is a dental test, my lord. These are the tests. Supreme Court said that you can give plus or minus 2 of benefit to it if the person to the accused, not in the case of a victim. That is, suppose in case if a minor child commits and his ossification test is done and he is determined to be about 17 years. So you have to add to it and 19, so he is a major. If you have to reduce 2 years and make him a minor. So benefit of doubt is given to the accused for determination of age when it is coming to medical examination. But in case if this is available, ossification test and other test, my lord, other certificate becomes redundant. That is what they said, my lord. For that purpose, my lord, there are 3 judgments of Supreme Court which I am going to point out. And 2 certificates, my lord, that is given by the SSC board and the school transfer certificate and the SSC certificate given to the school, which I have it in a sealed cover with me, my lord. I'm just passing on to your lordships. May
Are they
kindly look
different
at-
from what the PP has given?
I don't know.
PP
my
has
lord.
already given the data.
Yes,
SSC
Milord,
SSC
10th
chair.
class, yes, 10th class certificate and also Milord GHN certificate.
Both of them have same date,
Yes, Milord. Yes,
Even-
2008.
Yeah, but in any case, my lord, your lordship may, I'll just pass it on, my lord.
Yes.
Milord, 12/8/2008, there is no dispute, already Milord.
That's what it says.
Therefore, their inquiry
No,
also
according
revealed.
to them also, it is 2008.
So
Yes,
therefore,
madam.
she is a minor, my lord.
Only one more thing is, they are relying upon a charge sheet where there is no date of birth mentioned,
That
age
is,
was mentioned. as
that will not, my lord. The first
So
and the
that's only-
foremost thing, all that will become redundant, my lord.
Yes, now there
What
a-
is admissible now at this stage, prima facie for us to. Now, if they want to dispute these documents and say that is right and it is for them to agitate in the course of trial,
I don't think.
take advantage of it. No, but not for the determination at
Are
this.
you disputing this date of birth? or anything?
Leadership recollects, I said, at the stage of bail, Supreme Court said age will not be looked into by the court for grant of bail. I will have to therefore argue on the basis that she is 17 and a minor. That's why today I did not, but my friend is right on a point of law. Jarnail Singh, my lord of the Supreme Court, my lord, my learned friend is correct. He said that Juvenile Justice Act presumptions would follow. Therefore, not today when I started also, I said I'm not relying on that charge sheet. I never referred to it today.
Because the other day they were agitating and the grounds of their application also shows they were relying on the charge sheet. They picked up the charge sheet which seems to have been filed in the year 2021 that they brought in to show, and that is what is the basic crux of their application. That was the thing. So therefore, my lord, I thought it is better I produce the
No,
same.
as time passes, as you get more information, you become wiser, right?
My lord. In any
Yes.
case, my lord, now that they have considered and said that is what, my lord, that rules the roost, my lord. It says that first and the foremost thing is the SSC and the transfer certificate, which I have placed before your lordships, is the one which has to be taken prima facie for now.
All right.
If they are disputing, it is for them to take advantage in the trial in case of anything else. So therefore, now the other judgment, what they are relying upon is the Vardarajan's judgment, my lord. Vardarajan's judgment, 1960 Supreme Court is a judgment where we went away. It is for kidnapping. He took away in his cycle. I remember the facts of the case. I argued this matter long time back, about almost 20 years back, before His Lordship Justice KB Sitappa. My lord, in that case, my lord, she goes away. So that is after trial. He was convicted. They said now that she has gone away and the verge of majority. Therefore, we are letting off. That is what they said. Not at the cause at the stage of bail, my lord. Therefore, my respective submission is all those judgments are in respect of the after conclusion of the trial, not for the purpose of bail, my lord. So, as far as the age is concerned, my lord, now it is then said even can be a mitigating circumstance to reduce the sentence during the course of trial. But for the purpose of bail, my lord, they cannot say that she is not a minor. She is a minor. Aggravating circumstances, mitigating circumstances don't come during the course of bail. They are, your lordships know Bachan Singh's case, 3-0 the murder case. What are the aggravating circumstances, whether a death sentence could be awarded or not, or whether any mitigating circumstances for which we can reduce the death sentence to life sentence. These are the things where even they all come during the course of trial. I have not come across any judgment where they use the word mitigating, but that does not have circumstances mitigating to give anticipatory bail. I don't think, my lord, I have not come across. At least let them demonstrate, my lord, and show if it is there, my lord. Then, my lord, your lordship may kindly take up then the other point, my lord. Then there are some judgments, my lord, that is U Prakash versus AR online 2023 SC. So paragraphs 13 and 14, my lord, and I am giving a brief note also, my lord. That is paragraph 13 and 14 of your Prakash versus State.
So this
AR
contains
online,
your
my lord.
counter also.
Yes, my lord, a brief counter.
Counter.
Yeah, written, my lord, so that for the benefit of this
Yeah,
honorable
your
court, my
arguments are all
lord. They are there, my
incorporated.
lord.
Yes.
I didn't want to waste much the precious time
Yes.
of this court, my lord.
Yes, your Prakash.
My lord.
Hmm.
My lord, then with regard to the 161 statements, my lord, what I respectfully submit is, my lord, it is a mother who has gone and given the complaint. Whether she consulted the advocates or not, these are not considerations for this at the stage of bail. Maybe during the course of trial, they can cross-examination and say you took the advice of the advocate or you went to the advocate and deliberately. State they were not recording. That is what she communicated. But now I come to know from the public prosecutor on the same day the inspector recorded everything and they went and they changed the alter the section the very next day. So what is there the delay? And naturally, my lord, in these cases, Supreme Court said delay does not matter because these cast a stigma, my lord. Imagine if my daughter is there and she is undergoing, my lord, I would think twice, my lord, whether should I go or should I not go. 101 times I will think whether should I go or should I not go. The father was not inclined, he was saying, Enduku, but he had to. But in between, what has happened? One mediator came. So why I am saying bail should not be granted, that also I have written in my paragraph, my lord. I'll just point out to your lordships. Your lordships may kindly take up the complaint for a minute, my lord. It is not that the complaint is bereft of the main details, my lord. It has got. It indicates that this is what she had told the mother. Actually, my lord, they wanted to get married. That is what is there. She has gone with him. She has communicated. Obviously, when you are planning to get married, my lord, there are so many things you will communicate. There's nothing wrong about it. Your lordship may kindly see it because my learned friend has picked up some paragraphs. I wanted to read the entire complaint, which are actually relevant, my lord. My lord, your lordship will say paragraph 2, my lord, for it. My daughter, being a minor at all relevant points of time, was approached and gradually drawn into a relationship by Mr. Bandi Bhagirath through mutual contacts in or around June 2025, initially by a person introduction and subsequently through social media platforms including Instagram and Snapchat. As so-and-so deliberately built trust with my daughter and induced her into relationship by making false assurances of marriage upon her attaining majority, thereby exploiting her emotional vulnerability. He said they wanted to marry, subsequently he refuses to marry. As rightly pointed out by my learned friend, probably yes, it amounts to 420 also, maybe we'll get it added, that's a different issue. Over a period of time, he exercised continuous psychological control, including restricting her educational decisions, isolating her independent choices, and subjecting her to repeated emotional blackmail. That is all irrelevant, my lord. Then, my lord, your lordship will see that October, dated 25th October also, my learned friend, that is also not relevant. Paragraph 6 is relevant, my lord. During this period, my daughter was taken to a private locations, including residential premises and farmhouses, and on 31st December 2025, 1st January, so and so, Moinabad. Further, wish to bring to your notice a serious incident that occurred on the night of 31st December 2025, continuing into the early hours of the 1st January 2022 at a farmhouse located in Moinabad, Anya Farm. They all went together because obviously she thought she is going to get married to him and all that, and the parents also, because as my learned friend said, it is a trust which is there, and it is a parent who trusts his daughter, and it is a daughter who would not, my lord, this thing, her father, that she will not do something which is against the wishes of the father. Then, my lord, on that occasion, my minor daughter was present along with so and so and his friends, consisting of approximately 5 boys and 2 girls. Identified to the best of knowledge of those 4 names are given now. Now, these 4 boys seems to have been approached by the police. They were rounded and all, but they are scared to tell because the boy is very influential and the father is a very big man. So they are not telling anything like that. So that thing is there. So, among others, despite her resistance, she was pressured to consume alcohol and all that. What she told me, my lord, personally what she tells me is that yes, once in a while we go and we drink. It is not that it is not. Now it is become a social norm amongst all the young children to drink and this thing. She says, but for the first time on that particular dinner, whether she has written that fact in that 161 statements are no knowledge, but she told me. She says, generally when I have a breeze or anything like that, I know how much I get intoxicated. But on that particular day when she had taken the breezer, after some time, she says, I was completely zonked and I don't know anything. and the next day morning when she gets up, she's completely naked. That is what she told me. Now I don't know what she's written there. Breezer. Thereafter, during late night hours, approximately was so and so, who was in intoxicated condition, entered her room and forcibly subjected her to physical acts such as molesting her. Your Lordship must see, touching her inappropriately on her private parts may not attract that. What offences which they have charged in the first FIR, the FIR initially. He even stooped for a foreplay. My lord, foreplay has got lots of meanings. I've gone to Google and checked. My lord, foreplay can be insertion and exciting the woman or the man. It is, my lord, in the act it says that a elderly woman or any person can also do for a child, of male child. So child now definition as per the BNSS, earlier it used to be male and female, but now they said they don't say, they say as per the they say child. They don't say minor. That has been deleted now. In the BNS, child has come into the entire definition still child has come into full play as per the POXO Act. They say in reference to POXO Act, my lord, touching inappropriate and on her private parts. He even stooped for a foreplay against her will in spite of her resistance, using urging for sex, literally urging for sex. Being a minor and placed in a vulnerable situation, she is in a vulnerable situation. She was unable to effectively resist what he did. She couldn't resist due to the surrounding circumstances and influence exercised by the accused. So therefore, what could have transpired there, we don't know. We can't imagine. It is the girl who has undergone the trauma. And is it right for them to move an anticipatory bail in such a situation where she's been subjected to section 5 and 6? Now, what is section 5 and 6? Your Lordship may kindly see.
Yes, 5 is.
But there's nothing to shy away. The Act itself speaks.
Yes, yes.
Now the definition is child means any person below the age of 18 years. So she's below the age of 18 years. Now there cannot be an argument that just she is on the verge or something like that. That you take advantage as a mitigating circumstance to reduce the sentence. Maybe you will not get 20 years, maybe you'll get 3 years. Who knows? We don't know. Maybe they will take that into consideration. Now what this is, section penetrative sexual assault. Section 3 for a minute, your Lordships may see there it is. A person is said to commit penetrative sexual assault if he penetrates his penis to any extent into the vagina, mouth, urethra or anus of a child or makes the child to do so with him or any other person. He inserts to any extent any object or part of the body not being the penis, anything, and the vagina, the urethra or the anus of the child, or makes the child to do so with him or any other person, or he manipulates any part of the body of the child so as to cause penetration into the vagina, urethra, anus or any part of the body, the child, or makes the child to do so with him or any other person. This is, my lord, is punishable by only 3 years. By punishment is about 10 years. Now aggravated form is 20 years. What he did was 5L. It was circulated everywhere. It is 5 it is not 5 it is 5L. 5L says, my lord, whoever commits penetrative sexual assault on the child more than once. She explained in the statement what all he did, where all he inserted, what he inserted, everything she told. Now in such a situation, my lord, can this court grant anticipatory bail? All the judgments what my learned friend has filed are the 3 Supreme Court judgments which they have filed. Supreme Court has got plenary powers, my lord. They are unfettered. Sky is the limit. Now we are sitting under under 438, my lord, which is equal to 528 of the BNSS, my lord. Now, unnecessarily they change these numbers and cause confusion to us. So, what to do now? It has become like that. Now we are learning again. I am almost equal to a law student now.
It's difficult to unlearn. Maybe you learn now, but unlearning is difficult.
Unlearning is
You have to unlearn and then learn.
That is right, my lord. I agree with you. I never realized that. So, my lord, what has happened in this situation is, my lord, that they have invoked that section, my lord. So, therefore, my lord, in matter of speculation, anticipatory bail should not be given. In what circumstances? That's the Sibia's case, what my learned friend was relying upon. They said, what are this thing, my lord, I've given, because it's a very big judgment, my lord. So, therefore, what they say is, in what circumstances anticipatory bail should be given is the enumerated, my lord, about 8 parameters. This is page 40, my lord, of Gurbakh Singh Sibia's case,
You have given the paragraphs here.
1978 Criminal Law Journal, page 20, arising from Punjab and Haryana High Court. I'll just read, my lord, and for the benefit of my friend, I'll just read and pass it on to him, my lord.
Relevant paragraph.
Paragraph, my lord, 67. They say, my lord, in the next column, however, for the sake of starting, my lord, 67 is the paragraph in a matter of such significance. So, this is criminal law journal.
Para 67 starts with
66.
the specific issue of mala fides.
Probably, my lord, this matter went to Supreme Court, so I think this is the High Court judgment, my lord, wrongly picked up. But in any case, my lord,
This
I will
is
just pass
the
it.
Punjab and Haryana.
Punjab and Haryana.
Mm.
My lord, it starts with the opening paragraph rendered by His Lordship Justice S.S. Sandavalia, Premchand Jain.
Yes.
Yes, same judgment, my lord. Probably the paragraphs numbers are changing. If your lordship sees the concluding part before the penultimate section, they say, in a matter of such significance, you have necessarily been compelled to consider in it the depth and deal with it at some length. However, for the sake of clarity, that 8 points they have mentioned, my lord. We would wish to summarize our main conclusions in this regard in the following
This is para
terms.
64.
Maybe. Here it is 67, my lord.
Para 64. Yes.
In addition, 4, my lord, in addition to the limitations imposed in section 437, they said it should not be read in isolation, it should be read with 437, my lord, in conjoint with 437. CRPC, the petitioner must make out a special case for the exercise of power of grant of anticipatory bail. This is the
High
same
Court.
thing, no?
High Court. This
Sandavalia.
is Punjab and Haryana High Court.
It was
Full
set
bench.
aside by the Supreme Court, my lord. Gurbakh Singh Sibia.
Yeah, but these points are enumerated by them. That is why.
The decision now he has given and he's relying upon is the.
These are the
decision of
points, my
Punjab
lord,
and
which
Haryana.
they said that
This High Court judgment was set aside. My lord, Gurbakh
Set
Singh
aside.
Set on
Sibia,
some points, not on
the Supreme
entire
Court
judgment.
judgment, my lord, my friend is right, is the leading authority on the grant of anticipatory
Yes.
bail.
But in any case, your lordship may kindly, my lord, skip over for this moment since my learned friend is relying on that judgment. What I respectfully submit, my lord, for considerations for anticipatory bail, my lord, what has to be looked into are the parameters. First is whether there is a strong prima facie case or not. In this case, there is a strong prima facie case, my lord. So therefore, the question of granting anticipatory bail in such cases does not arise. The other 3 judgments, what my learned friend has cited are, my lord, the first one is yesterday, my lord, they have passed on 3 judgments to me. One is a Shaitan Singh Jaipur bench, my lord, which has arisen from Jaipur bench, went up to Supreme Court, my lord.
ఉందా శైతాన్ సింగ్ అని ఉందా డిక్టేట్ చేస్తున్నా సుఖ్వంత్ సింగ్
Judgment.
సుఖ్వంత్ సింగ్ అన్నది
First one, my lord, if you,
ఇట్స్ నాట్ శైతాన్ ఇట్ ఇస్ సుఖ్వంత్ interim bail pending disposal.
my lord, my learned friend had given one judgment arising out of from Supreme Court. The cause title is, my lord, Shaitan Singh. Yesterday he had given, my lord. He had passed it on to your lordships, my lord.
Because
In that, my lord, it is bereft of the facts. So therefore, I went to the original judgment, my lord, of the Jaipur bench, and there they have said that it is pertaining to section 7 and 8 of the POSCO. The page 1 of my material paper, if your lordship see,
So this is a Supreme Court judgment confirming the This one, Rajasthan High Court perhaps. So you have brought out the Rajasthan High Court judgment.
I took not have any facts. I wanted to see in what case they have given that, because they have not, don't even mention the sections. So they say that section 7 and 8 was a section. Section 7, 8 and are punishable with only 3 years, but still that High Court did not give. Therefore, Supreme Court, what they did was, in their judgment, notice to the respondent, that is a state, and they said, meanwhile, we are not to arrest, and over a period of time, they found that the conduct of the petitioner was good, therefore they granted anticipatory bail. Supreme Court, that is what my learned friend is relying upon. That is one judgment. I will come to that point. I will add one point to that, my lord. Then the next judgment, what my learned friend has placed. Weaker the case, more the cases. Citations.
You have given around 6 decisions here.
One more judgment, my lord, they have given is Anash versus State of NCT
No,
of
but
Delhi.
in this paper book that you have given, except for the first one, Shaitan Singh, and your
POSCO Act is there. POSCO Act
Just to
is
help
there.
my friend, today's compilation also is there. Anash is there.
It's there.
Today I gave one compilation in the
yes, yes, yes.
Serial number 4.
In that, my lord, if your lordship turns to page 2, by order dated 16/5/25, this court passed the following order. That is, Supreme Court passed. Issue notice to respondents returnable on so and so date. Petitioners' counsel is permitted to serve the standing counsel for the respondent's date. No coercive steps shall be taken as against the petitioner herein vis-a-vis FIR number 130 and 2025 dated 18/3/25 of Wasirada Police Station, North Delhi. Her learned counsel of so and so, so and so, so and so. What they say, next page, my lord. Per contra, the next page, learned senior counsel and learned SG appearing for respondent state with reference to the counter affidavit submitted that there is no merit in this appeal, and until the interim protection was granted by this court, the appellant had no cooperated with the investigation. Concluded there had been delay in the completion of investigation and all that, and they say we therefore allow this appeal, and then they allow the anticipatory bail. That is what is saying. Now the next judgment also my learned friend is relying upon is where also there also, my lord, same thing happened. That is, this is Nawab versus State of Haryana, the third judgment. In that also they say, my lord, notice paragraph 2, while issuing notice on 27/11/25 by way of interim relief, direction for not taking coercive steps subject to cooperation investigation was issued. And then subsequently, over a period of time, they found that he was cooperating, and then whatever it is, my lord, they have done. Now, all these three judgments, my lord, I respectfully submit have been placed before the High Court, before the Supreme Court, after inviting an order from the High Court where they have rejected, and for whatever reasons, because, my lord, their powers are plenary powers, unfettered. My lord, they are absolute, my lord. Sky is the limit for them. They can say anything, they can do anything. They tell us in a judgment, a recent judgment, they say you cannot give stay of arrest, you cannot pass, no coercive step shall be, High Court shall not do this, they say. But they can do, because they have powers. Not that we don't have powers, we have inherent powers, or under 226 we can do it. But compared to that power, my lord, our scope of our power is limited. Though they say High Court is equivalent to Supreme Court, but again they try to boss over the High Court. That is a different issue, besides the point. So what I respectfully submit to your lordships is, my lord, that in all these three cases, where none can question, but where is the judgment of this Honorable High Court, where they say in all other, Bombay High Court and all other cases, they have given some circumstances. Yes, Amma? Same thing. Now the ninth judgment with my learned friend as a Swami Avimukteshwarananda. This is Allahabad interim bail granted. My page number is
So all the other three, 9, 10 and 11 are different High Court judgments. They are High Court judgments.
I'm coming. Section 6342, Act Police Station, or Dilip Kumar, Senior Counsel, Assistant Rajesh Gupta. But in any case, my lord, one of the judgments of the Supreme Court said in FOXO cases, you should not grant bail. Now, how these people are, whether these have been tested on the anvil of the Supreme Court or not, we don't know. Whether they have gone to Supreme Court, we have no idea. Probably they have not gone, or maybe they have not been brought to the notice of Supreme Court. If Supreme Court comes to know that these kinds of orders are passed, and if they are placed before them, my lord, definitely they will be reversed, my lord. One of the judgments, my lord, which I have placed before your lordships is, my lord. Now, as far as the judgment which I placed, my lord, Yuva Prakash versus State, protection of child from sexual, where they have said, my lord, paragraph 13 and 14 are relevant for the purpose of determination of age. Your lordship may kindly skip over that judgment. Then Narayan Chetanan Chaudhary versus State of Maharashtra, Supreme Court also, my lord, there also at page number 21, that is the paginated page 21, paragraph 48. He also recorded the statement of the lecturer named Poonam Jairam Singh from the said school. She was in charge headmistress of the school. According to a certificate of TC from form and document at serial number 1 was issued by her school. As such, merely for the reasons that its copy was not there, the said TC form cannot be discarded.
This form was given the age, perhaps.
For the age, because I was referring to your lordship, that I'm just pointing out, my lord. Then the third judgment is also in respect of age. I will point out the relevant paragraph, my lord. I'm in the habit of sleeping at 8 o'clock in the evening and get up in the morning at 4:30.
If we had known next time, we'll do this only, my lord.
I go for golf, my lord, in the morning. 5:30, I'm in the golf course. So it has become a routine thing.
Now, are you sleeping or are you?
No, I cannot afford to sleep. I have to skip golf tomorrow in the morning. That is the only thing.
In the light please.
Then, my lord, one more judgment. Then your lordship will see, my lord, this Justice Gawai's judgment at page 49.
Yes.
Vinod Katara. My lord, this is at page 49, my lord.
Yes.
This is a writ petition arising for a very peculiar set of facts and circumstances. The petitioner was arraigned as an accused for the offence of murder committed on so-and-so. Petitioner along with 3 co-accused were convicted by trial court for the offence punishable at 302 section so-and-so. Then when the convicts include petitioner and preferred criminal appeal
this
number.
This is again with regard to the date of birth only.
Yes, my lord. Then the last judgment, my lord.
Page 49 is Vinod Tara. Sumit Ripa. No, this is not Vinod Tara is
my lord, last judgment, my lord, page 53, that why bail should not be granted in such cases, my lord, is rendered by Justice Thomas. This appeal is by the CBI assailing the pre-arrest order granted by the High Court of Himachal Pradesh in favor of the respondent on section 438 of the CRPC. Respondent was a former minister of the Himachal Pradesh state government, and he held the offices for about 3 years. Besides that, he was a member of the Legislative Assembly, and for that state also. His father, Sukram, was Union Minister for Telecommunications, CBI. He has been investigating case against the respondents, 13(2) of the Prevention of Corruption. Your lordship may kindly skip over the whole thing. Go to straight away to paragraph 6, my lord. They said that, my lord, custodial interrogation is a must, and therefore you have to give it. Anticipatory bail was granted. Now Supreme Court reverses it. That custodial interrogation is qualitatively more elicitation orientated than questioning a suspect who is well and concerned with a favorable order under section 438 of the code. In a case like this, effective interrogation of suspected person is of tremendous advantage in disinterring many useful information and also materials which would have been concealed. Success in such interrogation would elude if the suspected person knows that he is well protected and insulated by a pre-arrest bail under during the time he is interrogated. Very often interrogation in such a condition would reduce to a mere ritual. The argument that the custodial interrogation is fraught with the danger of the person being subjected to third-degree methods need not be countenanced. For such an argument can be advanced by all accused in all criminal cases. The court has to presume that the responsible police officer would conduct themselves in a responsible manner, and that those entrusted with the task of disinterring offences would not conduct themselves as offenders. So, and then, my lord, they say, next paragraph, my lord, they say, paragraph 8, my lord, the above observations are more germane while considering an application for post-arrest bail. Consideration which would weigh with the court while dealing with the request for the anticipatory bail need not be the same as for an application to release the bail after arrest. At any rate, learned single judge ought not to have sidestepped the apprehension expressed by the CBI. The respondent would influence the witnesses as one which can be made against all accused persons in all cases. The apprehension was quite reasonable when considering the high position which respondent held and in the nature of accusation relating to a period during which he held such office. Therefore, my lord, he was a former, therefore he had all the access to all the, and especially here the person is heading the home ministry, my lord, at the center. Obviously they will have, my lord, they will oblige, they will have to oblige. If a junior officer or IAS officer for his own purposes, most of them will oblige and in fact go and give information to him, saying, trying to please him, sir, this is the information, this is what. How did he pick up that information of 2021? Who knows? We also forgot about it. My client forgot about it, our client. And they say, we don't even remember, sir, it happened sometime, they say. But how did they come to know? Because somebody from that position has gone and said, sir, this is what it is, it will be useful for you. Not knowing the law, because this is the law. Anyway, my lord, now your lord, why I am opposing this bail and why there is a likelihood of tampering with the evidence, my lord. What happened during this course of this filing, prior to filing of this application, my lord. Now in the complaint, if you lordships may see at paragraph
About the mediation. or something.
page 12, yes, paragraph 12, about the mediation, you're right, but I'm coming to that. Your lordship may also see, they were putting pressure on them in March 26, they began receiving calls and indirect pressure to withdraw the matter. Means they were already pressurizing them, even before the case was, the complaint was lodged. On paragraph 12, on 21st April 26, a false and malicious complaint was lodged in Nirmal police station. Now what has happened was, on that day on which they went to lodge a complaint, my lord, somehow the information got leaked. Probably what they say is somebody from the social media or somewhere has leaked the information that prompted them to prepare a case which would act, which would make this case as a counterblast to the case, my lord. And that case, my lord, I'll come to it, is lodged in Karimnagar. Now, why it happened to have been, why it was lodged in Karimnagar, what was the reason it was lodged in Karimnagar, we do not know. Because it's assuming that the extortion of 5 lakhs which they are alleging, that this girl was doing some sort of honey trap, and then she took 50,000 rupees from this person, and then 5 lakhs they were demanding to compromise and things like that, my lord. Did it happen in Karimnagar? No, it did not happen. This man, the boy's father is a member of parliament from Karimnagar. So somebody gave that idea. I'm sure it is not, definitely not the advice of my learned friend, because he's so experienced that some person novice who is does not know goes, and this is going against
I
them.
don't think he came into picture then.
Yeah, like me. So therefore, what I respectfully submit, my lord, they went and did that. Then paragraph 14 for a minute, your lordship.
Yes.
Further, on 22nd April 2026, one Sangappa, claiming to be the associate with influential persons, visited our resident and facilitated, because by then they have come to know that this thing is, they are going to the police and things like that. He felicitated a meeting with Sri so and so on 23rd April 2020. That is the father of the petitioner. During this interaction, they went to their house. They went to their house and there was a talk. I don't want to say what he said, but he ridiculed her. That prompted them more. What they could have done wisely is not for me to say. They should have thought of it. Anyway, and disguised counseling with daughter and his son as a very forward, and we were subjected to indirect pressure to compromise and advised to sign some documents at Nirmal police station. The statements made during the meeting caused serious fear, intimidation, apprehension, particularly considering the minor status of my girl. And subsequently, my lord, it seems to have threatened him and all that. Indirectly, it seems to have threatened. They told what they said, but I don't want to tell here because I don't want to put it on record. So therefore, what I respectfully submit, my lord, that is one thing. The second thing was they go and pick up that FIR from Nirmal about the whole thing, lodge this complaint, and in my brief note I have mentioned 5 points. I have mentioned that passing on information to the Minister of State, that victim went to PS Pet Bashirabad to lodge a complaint. They go in at about 6:30, my lord. But already if at 5 o'clock their complaint is lodged there, and from 6:30 onwards up to about 10:30 they don't register the FIR. And next day when the matter came up and there was a hue and cry, the Chief Minister came in the papers. It came, that will come as a record in future course of trial. The Chief Minister seems to have asked, Honorable Chief Minister seems to have asked the Director General of Police that why have you not registered this case? It seems they told that the Honorable Prime Minister was here and we were there in Bandobast, and that's why they did not. What? Obviously, everybody wants to plead the MOS. So they and say, sir, itla information vachindi maku em cheyalante ventane akkadiki velli meer complaint cheyandi and all that, this all. So they're again trying to scuttle and derail the process. They shouldn't have done that. Then the influence exerted by the SHO paid Bashirabad to the registration of the FIR.
No, your imputation is that because of the position of the father, there is every
No,
likelihood.
letters have been addressed to the Prime Minister and the President of India to immediately decapacitate him from the position so that he will not further indulge into it. That is a different issue.
You might have taken all
That is a
steps,
different
but
issue.
Your
But
imputation now is that they are in such a position, influential.
everybody will
So
please
it is
them and
likely.
try to help them. That is what it is, my lord. Plus what has happened is, suppose assuming for a minute, a bail is granted. Whatever conditions, A, B, C, D, E, F, G, H conditions are imposed, will come out. What will be the fear which is there in the minds of the victim, your lordship may kindly see? And what kind of your lordship may kindly see? And what kind of encouragement they'll feel that they get elated, and they're challenging in the meetings and saying that, whatever will indirectly, they will say, no, we never threatened, we never said anything. But the kind of speeches and the kind of uproar, the way he is speaking from behind and in the TV and all, he looks as if, the Hitler is talking. I can see the Hitler movies is talking like that, and from behind the photo, the camera is put in such a nice way with the red lighting and everything. He says, my family may in a chest, I'm going to do this, why should they do that? And what will happen? Because it seems he has told the daughter that na kosam ento mandi chanipoyinar during, for my fan following is like that. So what are they saying? All this, my lord, will
not do.
We will not, but what I'm saying is, these things only are prompting. And there is a fear instilled in the minds of the convict. And what will the society think? In case if these kinds of bails are granted, that means these people of, but this will have an impact.
This court is not going to think about that. This court is going to
But
only
this
look at the
will-
law
this
and.
Whatever it is, what is there or what is happening, I'm just informing you. Lordship may not eschew what I'm saying. We will eschew it. That's the issue. So then what is happening is, then Nirmal case, third one. The fourth one is influencing PS Pet Bashirabad to register minor POXO cases. Now, your Lordship, why minor POXO cases? Should they not immediately go and inquire from the whenever a rape case or such happens, my lord, the police immediately rushes to the victim, because generally maybe rape has happened or whatever it is, and they are, since whatever reason it is, they have not gone, and they inform him, and they have not invoked the actual sections. Your Lordship, we are asking the honorable public prosecutor why they have not put. Naturally, they don't want to. They want to please him. or maybe he's already anticipating that such a case could be registered there. These things are common. This is how the society is going on. We see every day in and day out. So my thing is, there is an apprehension that the evidence could be tampered left, right and center. At least that could be curtailed in case if this boy is kept in custody, that could be curtailed. It will anyhow, they will do the tampering because they are in a very high position. So the judgment which I read in Sukram's case, where the Supreme Court said, Justice Thomas judgment, they say that in such situations bail should not be granted to people. And your Lordship may kindly see 50,000 rupees they are saying that she has taken. Page 12 of my this thing.
Yes, you have given some.
My lord, there is a repetition at the bottom, page 12, 2nd August 2025, 20,000, 30,000. What he used to do is send money to her. He is saying, why are you sending money to me? She immediately returns 50,000. 3:11 p.m. he sends. 12:21 he sends the money back. Then again 50,000 he sends. Then the next day again she will send it back. Just like that, he is sending money. And if you tally the total account, the money which left from the account of the girl is more than the money what she received. He simply said, they took that as an advantage, saying that we already paid advance of 50,000 rupees and they demanded 5 crores. What is this, my lord? Is it not amounting to an attempt to tamper with evidence or trying to create some evidence to show that this case has been as a filed as a counterblast to that case? Like that, my lord, 40,000, 40,000. He sends immediately within seconds, she's sending back. And somewhere she says, page number 14, he says, I love you, I love you, I love you. She doesn't reply. She says, bye. Then, I love you, I love you. In the last she says, bye, po, die. She says.
These are all the film dialogues.
She's after her. Right from the beginning, my lord, basically induced her. In other words, he used her, and once he dumped her, that is a different offense. But what he did to the minor, my lord, there cannot be consensus. In the ground, how can there be consensus? You cannot lay your eyes on a minor. Forget about consensus. Even if she consents, goes and voluntarily does anything with him, that is prohibited. So my respectful submission, my lord, this case doesn't deserve an anticipatory bail. And then page 17 and page 18. He is not a first time offender. There are 2 FIRs against him. One is he beat up, ragged somebody and beat up in his college. Sir, let me finish. I'm finishing. Please wait. Dondigal PS. Lordship may kindly read the contents.
Anyway, they are not nothing to do with this case. No, see, a person may have.
No. Supreme Court said,
Each
while
case
granting
has to be
anticipatory bail, if he is a first time offender, he is already an offender in some other cases, sir.
Maybe.
It's not that he is not used to going to police station and seeing these things. He cannot go under shock or something like that.
No, if it is same kind of offense, then yes.
To my knowledge, there are 4 other girls. I am not, they will come out soon. This is what I've heard. I'm not sure, but they're scared. I said, unless and until they really come forward and go to the police station, none can help them. Don't even come to me. Somebody approached. Now, I don't know the truth or otherwise of it, but this is what I've been told.
Yes, okay. That's all. I think.
I'll go in the reverse order, my lord. Those 2 FIRs have been quashed by this honorable court. Because there is some background to this person, my lord, they have filed cases. My lord, I have the order copies which I am placing, so there is no criminal antecedent. This argument may appear. Just give both them copies. My lord, then, my lord, very quickly, just 1 or 2. I will not take more than 5 minutes. Lordships may have the complaint because the learned public prosecutor started with para 6. I just wanted to show para 12 and 14. My learned friend referred. Just very quickly, my lords. Page 17, para 6, last 4 lines. The learned public prosecutor argued this would amount to penetrative sexual assault. Complaint, page 17. Para 6, last 4 lines.
Yes.
But I'm not reading it. Your ladyship has seen it. I'm just requesting your ladyship to just see it once again. Last 4 lines, because this is what the learned PP wanted to show. Last 5 lines. Correct, my lords? Now your ladyship may kindly have, my lord, POXO Act. Original offence charge, my lord, of FIR registered was for 11. Ladyship may only see 7.
Yes.
At best, even if they wanted to give, my lord, full benefit to that statement, it may amount to the sexual assault under section 7. Ladyship sees the entire definition. 8, even for this section, punishment, my lord, shall be less than 3 years, which may extend to 5 years. So below 7 years. It is not penetrative, it may not apply. But then the complaint, Lord, my friend referred to 2 more paragraphs, so that don't come back to that again. Lordship, ladyship may see para 12. Now I do not know the details of this complaint filed in Nirmal,
Yes.
but if your ladyship sees para 12, now this is the mother's complaint. Second line, on 21st April, a false and malicious complaint was lodged at Nirmal police station by Mr. Sriram, who is known to my daughter and was earlier introduced by her to the main accused. It is not, my lord, the accused person's friend who is introduced to her. It is her friend. We do not know why her friend filed a complaint against her. My lord, I do not want to speculate and I do not want to say, because my learned friend referred to this, that this is, my lord, a precursor complaint for the purpose of intimidation. It cannot be. My lord, 14, my lord, is an issue with relate to, my lord, my learned friend referred about, my lord, certain intimidation. My lord, and the person, father being in an influential position. My lord, 2 things. Since your lordships are hearing the matter in the High Court, law and order is a state subject. This state is ruled, my lord, by a party which is of a different political party. And my learned friend fairly stated, my lord, that the Honorable Chief Minister actually makes statements and directs, my lord, certain actions to be taken. Now, what I am complaining of actually is this political opponents who are from a different political party are trying to go after me. My lord, your ladyship says, if I had the influence, there would not be an improvement. There would not be an alteration memo. The fact that, but now complaint, it is no allegation that 8th complaint police prevented her from adding details. 8th complaint is a mother's own complaint, my lord. It had full details that the mother wanted to say. That is the complaint that is lacking. 9th is, according to my allegation, improvement. Who makes the improvement? Police in collusion with them. Because police is also, my lord, not from my party. Law and order is not state. When I say my party, my lord, I'm saying my father's party.
I'm sorry that my friend is making that.
No, my lord, I'm not trying to make any allegations. I'm trying to deal, my lord, with the allegations that the father of the accused is an influential person. But I'm saying, if your ladyship sees the circumstances show that if the father had actually used influence as is being alleged, it would not have worked in this particular manner. I am saying the police may have discharged their duty at this stage. I don't need to do anything more in an anticipatory bail. So this argument for the purpose of an anticipatory bail that the father is used his influence for preventing, your ladyship actually sees. 8th is the complaint filed by the mother, unhindered, unimpeded, without any police stopping her. 9th is, my lord, where the police are going and recording the statement. My learned friend referred to, my lord, his confidential conversation with the client. My learned friend, luckily, my lord, did not give a 161 statement, my lord, so I don't have to deal with it, apart from it being, my lord, privileged communication. So, my lord, then very quickly, 2-3 more points and I'll conclude, my lords. My lord, mitigating circumstances, both the judgments I placed are not at the trial at the stage of punishment. Those 2 judgments refer to previous judgments and they refer to this being a mitigating circumstance for the purpose of grant of bail. So, my lord, not at the stage of trial. Gurubaksh Singh Sibia specifically says the context in which the offence is alleged will be taken into account for the purpose of grant of anticipatory bail. But the 2 Supreme Court judgments, the 3 Supreme Court judgments my learned friend referred, well, this is not under Article 142 jurisdiction. That compilation only for a minute, your ladyship may just have.
The one that you have,
Yes, my lord, today. My lord, Anash judgment,
yes,
which is serial number 4.
yes,
My lord, at internal page 3 of that judgment, my lord. Pagination is the bottom of the page.
yes,
Internal page 3, second para. Considering the circumstances on record, in our view, the appellant is entitled to the relief claimed under 482. 482, my lord, is old 438, anticipatory bail that I am seeking. My lord, the next judgment, Nawab case, internal page 4. (482) CRPC, basis for grant of bail and conditions to follow under that section, which is, my lord, the jurisdiction your ladyships are exercising. Then next judgment, Ram Nivas,
so you're saying that all of these are judgments which are.
under 482.
Under 482.
482, which is the jurisdiction, not under, my lord, 142, where, my lord, then your ladyship may be persuaded to think that that may be a different jurisdiction. These are all under 482. Third judgment also, page 3, under 482, my lords. So this is, my lord, the judgments that are rendered under, my lord, the 482 jurisdiction. My lord, then there was, again, my lord, one slight contradiction, because I am not privy to the 161 statement, but if I have heard my learned friend correctly and subject to correction.
No, he has given you the copy of.
No, my lord, we are not entitled to. My lord, we are not entitled. So my PP is right. PP is right.
PP has given the copy only to the court.
Yes.
Maybe, my lord, if my understanding is correct, subject to correction by Mr. Nageshwar Rao, maybe, my lord, the copies could be shared with victim, because the victim should have a right, but at this stage, I cannot ask for it. So your ladyship will have it.
I did not given even victim also.
That's fair. My lord, I am therefore not saying I am entitled. I am only making one submission.
Only,
But I am talking about, my lord, my learned friend.
This honorable court only.
Yes.
But I'm talking about my learned friend, Mr. Pappu Nageshwar Rao, senior counsel's argument. But when he referred to the conversation he had with the client, but if I have heard my learned friend correctly, the client seems to have said on 38th, after having a breezer or two, she was knocked off until she woke up in the morning. Correct, my lords? Now, your ladyship sees the complaint filed by the mother where the serious allegation is made. That means the mother's complaint of what happened between 1:30 to 2:30 or 3 then starts becoming a contradiction. Now, these are matters that need to be considered. And I'm sure what the lady would have told my learned friend is completely correct. If that is correct, then what she would have told the mother may not be correct. Maybe she may not be recollecting things correctly. Now, this is what helps my case. This is exactly that on the basis of, if what my learned friend confided, my learned friend's client confided to my learned friend, as my learned friend spoke before your ladyship in the court today, that she was completely senseless from the time she had breezer and then she woke up in the morning. But then please see the complaint, entire allegation, including with regard to that limited offense, which is not penetrative, happened at 1:30 according to them, 1:30 or 3. And your ladyship may see the statement under 161. I don't have a view. What she is saying, she's saying something different to the counsel. Respectable counsel, one of my favorite counsels in the criminal bar. So, my lord, my respectful submission is these are matters, and which is why, my lord, the High Court judgments also are all under that. Lord, we are not getting off scot-free. We will go participate if you are able to pursue your ladyship. And tomorrow, if it is found, your ladyship are not discarding the improvements also. There are two judgments, my lord, that improvements cannot be taken into account. They'll be viewed with suspicion and just passing.
So,
But deeply grateful, your ladyship has
actually, I
been.
thought of passing an order today, but with the volume of case laws and so many material that you have given, now I cannot pass orders. Mali approved next to vacation court loan. I can't even pronounce in between.
But I have
Order
only
will
one
have to be
request.
passed only when
Yeah,
on the
but
next
I have one
vacation.
request, because my lord, since your lordships are now reserving the matter on anticipatory bail, it will be in your lordship's domain and your ladyship would take its time. Because this matter has now engaged the attention of the court and ladyships have heard. Ladyships may only direct the police not to do anything in relation to me till your ladyship passes the order. It can be, my lord, it's in your ladyship's hands. I'm in your ladyship's hands, my lord. Because we understand your ladyship, in fact, sat till 11:30 at night. But I don't know how your ladyship managed. My lord. It was from 10:30 to 11:30.
I think I got this virtue from my father. He had a lot of patience and I got it from him.
But my lord, I must also say one thing, which is compliments to my lord, both my friends on the other side. we never get this satisfaction arguing before the Supreme Court. It's never conducted so orderly. Everybody shouts at the same time. Maybe your ladyship schooled all of us yesterday. All of us were good, well-behaved children today.
No, most of the time, all of you are. Sometimes, yes, you get carried away, but
Yes,
yes.
Yeah, I just, with regard to the contention, what my learned friend says, that the Honorable CM is against them or some political rivalry or something, because there was a hue and cry. That is what I said. So that may be considered. And then, my lord, I have already explained to this Honorable Court, my lord, everything may not be told to the mother. Now that everything has come out, what is there for her to hide? It is after giving that 161 statement to the police that the third day she comes to me. Till then, I don't know what was happening actually. And my lord, the provisions what my learned friend is saying, the Supreme Court has got powers. They only mentioned that obviously anticipatory bail has to give in under that provision. Just by mentioning that provision, it would not be that High Court, Supreme Court has given under that provision, though that is not, because it went under 136 and generally, my lord, SLP. Your lordship see, it is an SLP. So therefore, and they have invited an order. It is not that they have passed an order at the threshold, because the lower courts have dismissed those applications. They went to them and then they have passed.
Consider.
So they have all the powers. I mean to say that it will not be safe and proper for this honorable court in such a case. It is not safe to grant any relief to the petitioner.
My only prayer is, since my lord, your ladyship has heard us elaborately, till your ladyship passes the orders, let the police be directed not to arrest my lord.
And any interim, my lord, I would just want to, my lord, for academic purpose, under what provision are they expecting this honorable to go give interim relief? 482, read with 482, that is what their application, that is old CRPC or under 520 of BNSS.
480. 480, no? The bail.
482 is 528. Ante kada?
438. Now 528 for Malad.
I'm talking about 482 CRPC. Let us get back to that, my lord, to avoid confusion. Now, under 482 CRPC, this court is not sitting under 482 CRPC, number one. Where is the provision under 438, my lord, to give that interim egnum relief? It is not there. That is what I'm saying. Old one, right?
That's why he's
CRPC.
referring to CRPC.
CRPC it is. Old CRPC means you have to go back to 19th century. That is, I'm not talking about that. CRPC 482, my lord, is the only inherent power which is used to give that one. This court is not sitting in 482 in vacation bench. 482 is prohibited by virtue of a circular saying that no 482 applications can be entertained. That is why I didn't want to go into that arena, because any order of such nature has to be part. Your lordships have to use the inherent powers. And in the Niharika infrastructure, Supreme Court has categorically stated High Court should not give orders of not to use, give coercive steps or not to arrest. These things you should not give under 482. The same analogy applies here also. In 438, how can we give? Either the petition has to be dismissed or it has to be allowed. There is no via media. Unless your lordships are exercising the powers under 482. That is only. It has got vast powers. Inherent powers are not coming in that way. But in this case, at this moment, especially when there is a circular not to use 482, then, my lord, the question of exercising that power does not arise. That is what I respectfully submit.
Normally, my lord, I'll never venture to correct my friend on the criminal law aspects, but today's compilation that I've given your ladyship, today's compilation, from serial number 4 to 8 are all under anticipatory bail. Their inherent powers have been cited for the purpose of granting an interim protection. From 1 to 3 are all in relation to the anticipatory bail powers your ladyship has. There the Supreme Court said your ladyship can grant an interim protection. Now your ladyships have heard 430, this 482, which is old 438. 1 to 8 are all judgments of the Supreme Court which vest in your ladyship the power to grant an interim order. That's why we are arguing originally an interim order. Now since we have argued the main anticipatory bail and it has gone on till this time, till your ladyship pronounces the order, my lord, things need to be protected.
That may
But
not.
suppose that I'm only pointing out one anomally. If suppose, my lord, your ladyship day after tomorrow, my lord, we cannot hazard. Your ladyship may dismiss my petition, your ladyship may allow my petition. Until your ladyship reflects on it, we cannot be sure. But in that one contingency, if your ladyship may be inclined to allow. In the meantime, if they arrest me after your ladyships have heard, that relief would be remote for me. That's why I'm saying till your ladyship passes the order, let the police not be. Lordship may not pass an order, lordship may instruct the police also orally, or your ladyship may pass an order, whichever your ladyship thinks is appropriate. I'm only saying, let your ladyship's order be effective fully. If your ladyships are dismissing, they can arrest me at that time.
And the judgment
think,
of, my lord.
I don't think that, I should be granting any interim order at this stage. I'll pass orders on the next vacation court day. I'll pass a detailed order.
Only one
Very well.
problem.
The
It's-
anticipated date.
Yes, my lord. It is till next Thursday,
Next
5-6 days, my lord. But I'm only praying
No,
since your
because
ladyship-
I would like to, maybe I will like to pass orders by Monday. But because of the vacation, I cannot do it. I can only pass on the next vacation.
But
I
till
cannot
that time, my
pronounce.
lord, I meant lordships may consider granting some status quo. My lord, or I also said when I was arguing that, my lord, in the meantime also, so that, my lord, I don't delay the investigation, I'll participate in the investigation. They can submit a report to your ladyship also. Let there be a court, my lord, they can submit a report by the time your ladyship passes an order also. But in the meantime, my lord, I'm only saying, if I'm able to persuade my ladyship on your ladyship's reflection that I'm entitled to the grant, in that perchance, my lord, that 1 week may be too late, my lord, for your ladyship to give me effective relief. So I'm saying, my lord, let that course of justice not be, my lord, disturbed. So, my lord, I'm only praying, my lord, 8th of May is the FIR. Incident, my lord, is the 31st of December, 1st of January. Your ladyships are hearing in the month of May, and your ladyships have burnt midnight oil literally for hearing this case. But 1 week, and your ladyship may impose stringent condition even still then, my lord. I will go, I will my lord, appear before the police, I'll my lord, participate in investigation. And your ladyship may ask the police to give your ladyship a report, my lord, whether my participation is willful. They can report to your ladyship, my lord, if there's any interference or tampering. In the meantime, because your ladyship may grant them liberty, but till then, my lord, let them not arrest me. But in fact, in one of the matters, my lord, where there was a former police officer, where the Supreme Court directed, my lord, certain steps also. That there shall be a court monitored investigation that would go on, and my lord, the person would not be arrested. This person was absconding for a year. He came before the Supreme Court. And in anticipatory bail, my lords.
No, this is a
I think
totally
my learned friend,
different scenario altogether.
the difference, not only for guidance, my lord. But I'm only saying this, my lord,
I wish.
that since your ladyships have heard, my lord, I am saying, my lord, your ladyships initially commenced hearing it on interim protection. Since your ladyships have heard, it does not mean, my lord, your ladyships' power to grant an interim protection would be taken away. Because, my lord, next vacation bench will be a long date. My lord, I'm therefore requesting, let them not do anything in the meantime. I will go, my lord. In the meantime, investigation should not suffer.
My lord, last one submission I wish to, only just one line, my lord. The facts and circumstances of each case will be different in each of those cases, my lord. All these precedents which we have given or the other side have given are only for the purpose as a guiding factor. The facts of this case cannot be paramateria or something like that in the other cases, my lord. So while considering the 161 statement what my learned friend has placed before your lordships, my lord, your lordships have to read that and what she's saying and then take a call on that. And the other side was served a notice and they have taken 2 days to come. They said that I am a bit busy elsewhere as usual like any other case, and I'll be coming and seeing you in your police station. That has expired today. I wanted
What
to
is
go-
the notice that they have given? Have
I don't know, they gave a
35
notice to them, there is no such procedure. For that he answers. He answers saying that I am coming in 2 days. That has expired, that was given on some
Yesterday also I
13th or
told,
something.
if your
And
ladyships grant me
No,
interim
have they given you notice under 35?
no, not on the 30th.
Then no.
After modifying altering the sections they have
and your
given.
ladyships
They have
have
mentioned
heard the
5
police saying, my lord, anticipatory bail must be dismissed today. So your ladyship knows what will happen if I go. They are saying, no, don't grant
That
anticipatory
all they
bail.
have should have thought before committing this offences.
My lord,
See,
But
anybody
that-
will say,
that-
my
my
lord,
lord, I
One minute.
take an
What
objection.
I'm
One
saying
minute,
is-
1 minute.
Hello.
Yes, I have gone through the statement of the petitioner, though cursorily.
Not the
in
petitioner,
detail.
my lord,
Not
the
the
victim.
Sorry, the victim. Though not in detail, but cursorily. And after going through that, at this stage, I am not inclined to grant any interim order.
Very well.
ఈ పేపర్స్ ఇవన్నీ కవర్స్ ఉన్నాయి, పేపర్స్ అన్ని ఇచ్చేసారు ఆల్రెడీ, అన్ని ఇక్కడే ఉన్నాయి.
Then
ఉంచు.
I can only make one final request. Since it's in your ladyship's domain, but may only beseech, I understand the difficulties, my lord, the court has. But would your lordships, my lord, kindly consider our request so that the final orders can be passed at the earliest. My lord, I know you are
So
troubling
that's
your
what I
ladyship.
asked him, because during vacation, I cannot pass any order.
No, my lord, any
Please.
day.
Huh?
My lord, any day. Vacation, my lord, yeah, because like in this very court, there was a vacation bench constituted for hearing a matter, my lord, of a central government public undertaking, which I was appearing for the state government in that one particular matter. Lunch house motion was moved. House motion was granted. So tomorrow, if someone moves a house motion, it could be a Saturday, my lord, maybe the court, if it feels the urgency, the court will sit. So it is not that, my lord, your ladyships are vacation bench only on Thursday or Tuesday. Your ladyships, my lord, and the other judges are vacation benches for this entire 2 weeks
If
period.
it's the case, then you'll get the order at the earliest.
Yes, my lord, it is,
Whatever it
that is correct, my lord.
No, no, I said amount only, 5 lakhs and 5 lakhs. I didn't say 25. Sunday court is there. RTGS. Bank transfer, you do it. Yes.